Good morning, Mr. Carter. Are you there?
Yes.
He's on the William.
So you just got to play
Oh, William Ball. Okay, but William Ball won't be here, correct?
court down there.
Okay. You're on the William Ball matter, sir?
Yes, Your Honor.
Okay, so we tried to read him over, but he had a court conflict, so he won't be here today. So we can reset.
That's not a problem, Your Honor. I was going to be asking for a different date anyways, as I just got appointed and I have no discovery yet.
Sounds good. Let me see here. Issue 2 files.
Yes.
Okay, were you appointed on just the felony or the felony and the misdemeanor?
Both, Your Honor.
Okay, very good.
I'm in the same position. I don't have discovery on either one of them.
Okay, sounds good. Right now, we have the preliminary examination on the felony. We have that scheduled for December 16th. Does that work for you?
At what time would that be?
At 8:30?
I'll be in Detroit at 8:30.
Okay. We will note that in the file, and I just hesitate to reset it right now because I think we're still waiting for other appearances. So we're gonna have to
Sure.
find a global date for all of the attorneys.
Sure, and that makes sense. Would it make sense to set it for another PCC maybe on the 4th, a week from now, to see where everybody is?
Correct. We're definitely gonna reset the PCC because we've not seen Mr. Ball in person yet.
Okay.
Can I have a PCC date for our time for next week?
I can put it on November 4th.
November 4th our time? Okay, next week at 8:30 work?
I'll make that work.
Okay, and we'll reset the examination after we get a hold or find out who the other, I think 4 we're still looking for appointments. So once we get those other 4 attorneys, we'll reset that.
Oh, is this a 5 defendant episode?
Oh, no, I'm sorry,
criminal
that's the
episode?
wrong case. Wrong case. It's the other matter that has the 5. It's he's on. It's the misdemeanor.
I
It's
do
the
believe there's
misdemeanor.
at least one other co-defendant, but I'm not sure if there's more.
You mean on the felony?
Yes. At least that was my understanding.
This one was, I don't know why this one was set for the 16th. This one doesn't need to be set for the 16th. Yeah, this is not part of the only one that was set for the 16th was the 6th co-defendant exam. Not this one.
Also, it should be.
Well, yeah, misdemeanor, I guess. Let me see. You can put the misdemeanor pretrial on that date. Well, actually, no, he needs to have a pretrial before then. He's a misdemeanor pretrial. What is it? They can, we haven't seen him yet. I don't see that there's a co-defendant on here.
Okay, I could be wrong.
At least the co-defendant tag was on this. Not the felony.
Yeah, I don't believe he has a co-defendant on the felony The misdemeanor is the one that there's 5 other co-defendants, but they have felonies.
Okay, maybe that was the conflict then, so I apologize.
No problem. I think that same confusion was evidenced in our notes in this file. So this preliminary examination should not have been set for the 16th. So we will do the PCC next week. Give me a exam date for the week after that.
Have to be 2 weeks, November 18th
Oh,
at 8:30.
does November 18th at 8:30 work for an exam date?
I'm sorry, you're on November 8th,
18th?
18th. Okay, let me look at that. At what time?
8:30?
I think I can make that work.
Okay, we'll set it down for November 18th at 8:30. If we need a change of date, we'll address that next week.
All right, thank you.
Okay, and then I need to reset his pretrial. How many days does Wayne County require for a writ?
It's probably the same.
7 days, okay. We can reset it for 7 days out, I guess.
same
Or the
thing,
Monday.
PCC thing.
The 4th? Okay, we are gonna do his pretrial the same day as his PCC, okay?
Okay, I'll make a note of that. Thank you.
November 4th. Okay, so that should take care of that matter for now. Anything else we should address while you're here, sir?
No, I guess would you like me to file my appearance by email? It's gonna go out in today's mail if not.
Yes, please do. You can send it to Judge Simmons' courtroom at lansingmi.gov.
Thank you.
Thank you.
Bye now.
I think other than that, you're all set for today, Mr. Carter.
Thank you, Your Honor.
Thank you. Have a good one. Who's representing Mr. Williams?
That is me, Your Honor.
Okay, let me find the file. On the record in the matter of the people of the state of Michigan versus DeVory Jawan Williams, file number is 21-02469. FY, counsel appearance.
Thank you, Your Honor. Erin Housefield on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Williams.
Thank you. And today was the date. Mr. Williams, can you hear me?
Yes, ma'am.
Okay, thank you. Today was the date that was set for a preliminary examination. My understanding is that there's going to be a waiver. Is that correct?
That's correct, Your Honor.
Okay.
That is correct, Your Honor.
Your offer extended at all, Ms. Hospital?
There was not in this matter, Your Honor. Thank you.
Okay, so the parties are unconditionally waiving their right to preliminary exam.
Thank you, Your Honor. The people would unconditionally waive their right to a preliminary examination and ask that the matter be bound over to the circuit court on the complaint as filed.
Thank you. And Mr. Nickel?
That is correct. And I have had discussions with Mr. Williams, and he intends to unconditionally waive his right to a preliminary examination and have the matter be bound over to circuit court today.
Thank you. Mr. Williams, you understand you have the constitutional right to have a preliminary examination here in the district court?
Yes, ma'am.
You understand that you have the constitutional right at examination to have the prosecution establish the burden of probable cause. So that's probable cause that a crime was committed and probable cause to charge you with that crime. You understand that?
Yes, ma'am.
You wish to unconditionally waive your right to examination today?
Yes, ma'am.
Okay, so that means you can't come back later and say that you would like to have your examination. Once you waive it, it's gone. You understand that?
Yes, ma'am.
So that means no hearing will be held here in the district court level to establish probable cause. This matter will then be sent over to the circuit court. That's what you want, sir?
Yes, ma'am.
Has anybody made any promises to you to get you to waive your right today?
No, ma'am.
Anybody threatening you to get you to waive your exam?
No, ma'am.
Okay, I find your waiver to be made freely and voluntarily. This matter will be bound over to the circuit court for a bind over date of November 10th, 2021. You will not need to appear in court on that day though, Mr. Williams. That's just the date the circuit court will receive the file from the district court, okay?
Okay.
They'll set your next court date, which will be a pretrial, and Mr. Nichol will be made available, made aware of that date. He'll make sure you know that information. Is he being held on something other than this?
Yes, he has a probation hold
Okay,
out of 2 different courts
okay,
and an extradition warrant.
okay. So the bond will continue. Any additional matters for the record?
Nothing for the people, thank you.
Nothing for the defense at this time.
Thank you. You're all set, Mr. Williams.
Thank you.
Thank you. Ginger Carrington. On the record in the matter of the people of the state of Michigan versus Kendrick Carrington and file number 21-02728FY. Council appearance, please.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Kendrick Harrington, who's standing to my right, Your Honor.
Your Honor, before the court continues, if I may, this is a case where Mr. Harrington additionally has court file 21-02683FY. The parties' plea agreement this morning will include both files. I did ask the court to have both felony files available.
I have both files.
Thank you.
I was going to ask, why do I have 2 files? Okay, so there's going to be a plea. That's
That
correct.
is correct, Your Honor. The defendant in file 21-02683 is going to plead to an added count 3 of use pursuant to 333.74042A-A. The maximum penalty on that is 1 year and/or $2,000. He's also going to plead guilty to an added count 4 of aggravated domestic violence pursuant to 750.81A. The maximum penalty on that, Your Honor, is 1 year and/or $1,000. In consideration for that plea, counts 1 and 2 will be dismissed. Additionally, in file 21-02728FY, counts 1 and 2 will be dismissed.
Mr. Ferguson?
Your Honor, that is an accurate statement of the plea bargain, Your Honor.
Okay, so there was also a PA 53 violation. Their recommendation for that to be,
There would be a recommendation, Your Honor, for that to be dismissed in consideration of the plea agreement.
okay, and Mr. Harrington, how are you today?
Fine, thank you.
Okay, and so you heard the plea that was offered, that you were gonna plead guilty to an added count 3 of use of a controlled substance, and then an added count 4 of aggravated domestic violence.
Yes, ma'am.
And that counts 1 and 2 in this file will be dismissed. The counts in file number 21-02728 will be dismissed. There's a recommendation to dismiss the PA 53 violation. That's the plea offer. You will recall yourself being extended? And that's the one you want to take, sir?
Yes, ma'am.
Are you sure about that?
Yes, ma'am.
I have a advice of rights and plea information sheet. It has today's date on it. Is this your signature, sir?
Yes, ma'am.
Okay, did you read this document?
Yes, ma'am.
Do you understand each of the rights listed there?
Yes, ma'am.
Do you have any questions regarding any of those rights?
I do not.
Okay, you understand that you have the right to proceed to a trial in this matter? You have the right to have a jury trial. At the time of jury trial, you have the right to have the prosecution bring sufficient evidence to prove each element of the charges against you. They need to prove each element beyond a reasonable doubt. You understand that, right?
Yes, ma'am.
If you want to enter a guilty plea today, you would have to give up the right to have a trial. You would not have a trial of any kind. That means you won't have an opportunity to cross-examine or question any of the witnesses that the prosecution intended to call against you. You won't have an opportunity to call your own witnesses or present evidence to further any defense you may have. And then you also won't have, or you'll waive the right to remain silent at trial and not have silence be used against you. Is that your understanding of the rights you're waiving today?
Yes, ma'am.
Has anybody made any promises to you to get you to waive your rights today and plead guilty?
No, ma'am.
Anybody threatening you to get you to plead guilty? Are you pleading guilty because you believe you are guilty?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Okay, you understand that if you were, that a conviction today could result in you having to have a violation of your probation or parole status. You understand that?
Yes, ma'am.
You also understand that a criminal conviction may need to be reported to your current employer, or you may have to put it on future job applications. You understand that?
Yes, ma'am.
Okay. You still wish to waive your rights and plead guilty today? Can you speak up?
Yes, ma'am.
As to the added count 3 of use of a controlled substance, how do you plead?
Guilty.
And as to the added count 4 of aggravated domestic violence, how do you plead?
Guilty.
Not a factual basis.
Yes, Your Honor. Mr. Mayor, turn your attention back to September 26th of 2021. We're at 5923 South Ridge Street.
Yes.
That's here in the city of Lansing,
Yes.
Ingham County, state of Michigan.
Yes.
And while there, you were using a controlled substance called meth. Is that correct?
Yes.
And you knew it to be meth. Is that correct?
Yes.
And while there, you were with an Amistad Barlett. Is that correct?
Amethyst.
Amethyst. I apologize. And that is someone whom you had a dating relationship with. Is that correct?
Yes, that's true.
And while there, you got into an argument with Miss Barlett. Is that correct?
Yes.
And what happened? Did that argument turn physical?
Yes.
And tell me from there what you did to physically escalate that argument.
We called each other a couple names, and I threatened her and told her that she called me by my name again.
Can you speak up?
I said I threatened her and told her if she calls me out of my name again, I'm gonna take this mirror. And as I was taking the mirror off, she was handing me to a drink, and it went through the mirror, and I hit her on the shoulder, and hit her on the side of her head. Took the mirror off the wall, turned at the same time, took her hand up to her shoulder, the mirror went off. It was in a big frame.
Let me ask you this, Mr. Harrington. Did you use the mirror to assault Miss Barnett?
She was assaulted with the mirror, yes, she was.
So you intended to use that mirror as a weapon towards Miss Barlett, is that correct?
Yes, it's happened. So, yes. Yes.
Or was it an accident, is that correct?
No, it was not.
Your Honor, I have no additional questions for this.
Factual?
Thank you. The people are satisfied with the factual basis, Your Honor.
The court is also satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Count 1 and 2, and the plea on this file will be dismissed, and the charges of the other file will also be dismissed per plea. This matter will be set for sentencing. Prior to sentencing, you need to meet with probation. They're going to provide the court with a pre-sentence report and recommendation, okay?
Yes, ma'am.
You should go down to probation as soon as you leave here so they can set that investigation up, okay, sir?
Yes, ma'am.
You're also going to have to undergo a substance abuse assessment, okay?
Yes, ma'am. Do I do that myself, or you guys have?
I'm sorry?
Do I do that myself?
No, they'll advise you as to where you can do that then when you go downstairs, okay? January, it's going to be January 7th at 8:30 in the morning for your sentencing, okay?
Your Honor, is that gonna be in person or over Zoom or still to be determined?
It could be via Zoom if all parties consent.
The people would consent, Your Honor.
Mr. Arrington, you have a right to be here in person for court, or we can do it over Zoom. That's your right to be present in the courtroom.
Not knowing what date I might be working.
What day of the week is
Time.
that?
The Friday. Friday.
It's a Friday at 8:30 in the morning. Yeah.
Zoom.
We will do it
No,
by Zoom.
no. I'm coming to court.
You're gonna come in person?
Yes, ma'am.
Okay, very good. We'll move to sentencing on January 7th at 8:30 in the morning. Any additional matters for the record?
Nothing for the people, thank you.
Just one for the defense. He has a bond condition with regard to GPS tether, Your Honor. I would ask if that could be removed, Your Honor. He does need to get to work. He doesn't intend to have any contact with Miss Bartlett, and given the reduction, I would ask that the GPS tether be removed.
I actually do not see GPS tether on this file. Let me double check. It was on the other that was dismissed. His bond in this file was set at 5,000 personal requirements, since I don't see where.
So if it's on the dismissed file, that issue is gonna be moved then. Thank you, Your Honor.
Oh, you know what, it was actually on the PA 53, it was on this one, when he was arraigned in the PA 53, they added it. I will remove the GPS tether.
Thank you, Your Honor.
Okay, you're all set, sir.
Thank you very much.
Okay, who is in the jail with the orange on?
Edward Zick, ma'am.
Okay, Edward Sick. Yours, Mr. Feigelson?
It is, Your Honor.
Okay, and who is in the jail with the blue on?
Corey Hale.
Okay, Mr. Hale. Okay, Mr. Abbott, did you need to speak to him at all?
Oh, thank you, Your Honor. I spoke with Mr. Hale yesterday. We're all set.
Okay, sounds good. Let me handle Mr. Zick and then we'll do Mr. Hale.
Unless Mr. Hale has any questions. I guess I should have asked.
Mr. Hale, did you want to talk to your attorney privately before you proceed?
Yeah, if possible.
Okay.
Okay. Okay, we're on the record in the matter of the people of the state of Michigan versus Edward Lamont Zick. File number is 21-021118FY. Council appearance, please.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Zick, who's present via Zoom this morning, Your Honor. I'll probably come, excuse me.
Today's the date that was set for a preliminary examination. How are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Zick intends to enter a plea.
Okay, what's the offer?
Thank you, Your Honor. The defendant is going to plead guilty to an added count 2, use of a controlled substance pursuant to 333.74042A-A. The maximum penalty on that is 1 year and/or $2,000. In consideration for that plea, Your Honor, the people would move to dismiss count 1. Additionally, I believe that Mr. Feigelson will be seeking a sentence under 7411. While the people are not killebrewing that sentence agreement, there would not be an objection if the court deems him otherwise eligible.
Mr. Feigelson.
Your Honor, that is an accurate statement of the plea offer today.
Thank you. Mr. Zick, did you hear the offer that was extended by the prosecution?
Yes, ma'am.
Okay, you want to accept that offer today?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Sir, you have the right to proceed to a jury trial in this matter. You have the right to be represented by counsel. You are represented by Mr. Feigelson from the Office of the Public Defender. If you were to proceed to jury trial, you have the right then to have the prosecution prove each element of the charge against you. You have to prove each element beyond a reasonable doubt. Do you understand that, right?
Yes, ma'am.
Okay, if you enter a guilty plea today, that means you're gonna have to give up your right to have a trial of any kind. Do you understand that?
Yes, ma'am.
So you won't ever have an opportunity to question or cross-examine any of the witnesses that the prosecution intended to call. You're never gonna have an opportunity to call your own witnesses or present evidence to further any defense you may have. You also waive your right to remain silent at trial and not have silence be used to prove your guilt. Do you understand that?
Yes, ma'am.
Has anybody made any promises to you to get you to waive your rights today?
No, ma'am.
Is anybody threatening you to get you to waive your rights?
No, ma'am.
Are you currently on probation or parole?
No, ma'am.
Okay. Are you pleading guilty because you believe you are guilty?
Yes, ma'am.
As to the added count 2 abuse of a controlled substance, how do you plead?
Guilty, ma'am.
On a factual basis.
Yes, Your Honor. Mr. Zek, I want to turn your attention back to June 13th of 2021, where you're at 915 Riverview Avenue.
Yes, sir.
That's here in the city of Lansing,
Yes, sir.
Ingham County, state of Michigan.
Yes, sir.
And while there, you came in contact with law enforcement, is that correct?
Yes, sir.
And you were under the influence of methamphetamine that day, is that correct?
Yes, sir.
The substance that you had taken that day to be methamphetamine, is that correct?
Yes, sir.
And you had no reason to dispute that that was meth, is that correct?
No, sir.
Your Honor, I have no additional questions.
Ms. Oswald, did you have any questions?
No, thank you, Your Honor. The people are satisfied with the factual basis.
The court is also satisfied with the factual basis, and I'm going to accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Prior to sentencing, you're gonna have to undergo a substance abuse assessment, okay?
Yes, ma'am.
So you'll with probation, they'll arrange to make sure that that takes place, and they'll provide the court with a pre-sentence report and investigation, okay, sir?
Yes, ma'am.
How long is he expected to be held in custody?
Your Honor, he is in on a sentence from Judge Ward. I think he's got another 4 or 5 months left.
Okay.
February 15th, 2022.
Thank you. On the sentence date,
January 7th.
it'll be January 7th at 8:30. I've noted here that you're under sentence until February 15th to 2022, so they'll make sure to make arrangements with the county to get you assessed, okay?
Yes, ma'am.
Do you have any questions today, sir?
No, ma'am.
Any additional matters for the record, counsel?
Nothing for the people, thank you, Your Honor.
Nothing from the defense, Your Honor. Thank you.
You're all set, Mr.
Thank you, ma'am. Have a blessed day. Thank you.
Same to you, sir. Let me see if I can get Mr. Hill back in here. Okay.
Have a good day, Your Honor.
Thank you. Okay, Mr. Hill, can you hear me?
That's APA Adam Pfeiffer, Your Honor.
Okay, very good. He's not here at this time. Okay, Mr. Abbott, when Mr. Pfeiffer is here, we'll proceed on Mr. Hill.
Okay, thank you, Your Honor.
Your Honor.
Thank you.
He's here, Your Honor.
Okay,
Would you like me to grab him?
that's fine. What do we have here?
Thanks.
This is Meacham John, Your Honor. Was it?
Who?
I mean, you and I both.
I couldn't hear you. Okay.
Oh, okay, well,
John.
I haven't had a chance to even walk into a hallway to check on witnesses, so give me a sec.
Okay, so you're waiting for an update from the prosecutor. On that one, John.
Yes, Your Honor. I haven't checked for witnesses just because we've been on the
No
record.
problem. I just didn't know if he was waiting to go on the
Very
record.
good. So we'll go do that and let Mr. Pfeiffer read his.
Good morning, Your Honor.
Hale, here we go. We're on the record in the matter of the people of the state of Michigan versus Corey Scott Hale. The file number is 21-02740FY. Council appearance.
Good morning, Your Honor. Adam Pfeiffer for the people.
Good morning, Your Honor. John Abbott representing Mr. Hale. We are both appearing on video this morning.
Thank you. Today's the date that was reset for probable cause conference. We were here last week, but we had to find good cause to adjourn this matter because Mr. Hale's application for court-appointed counsel was still pending. So, Mr. Abbott, you recently was appointed to this matter. We do have an appearance filed. How do we want to proceed at this time?
I've been in touch with Mr. Abbott. An offer has been made, and Mr. Abbott told me this morning that they wish to have the examination.
Okay, Mr. Abbott?
Thank you, Your Honor. If Mr. Pfeiffer could please put the offer on the record, but it is our intention to hold a preliminary exam.
Thank you.
I'd be happy to. The offer that was conveyed is that the defendant can plead to an added count of attempted strangulation as well as domestic violence third offense. The people dismiss the remainder of the charges upon successful plea and sentencing.
Okay, and so Mr. Hale, you heard that offer?
Yeah,
And
Yes.
you've discussed that with your attorney?
no, I haven't.
Okay, you've not discussed it with your attorney. Was this the first time you've heard the offer?
Yes, ma'am.
Okay, that's fine. Your attorney did just file an appearance 2 days ago. So this matter will continue to preliminary examination. I don't think we set it for a date previously, did we?
The 4th, November 4th.
Okay, is that the date of his exam, November 4th?
Yep.
Very good.
9:30.
9:30. So yep, we will proceed to examination on November 4th at 9:30. Is that offer staying open until then?
Yes, Your Honor.
Okay. So the offer will remain open until the time of the examination. Okay, Mr. Hale?
Yes, ma'am.
Okay, any additional matters for the record, Mr. Abbott?
Just, could I have another moment in the breakout room with Mr. Hale, please?
Absolutely. Any additional matters, counsel?
Nothing for the people, but if there's something that needs to happen after the breakout room, I'm more than welcome to stay here for it.
Very well, thank you. We're off the record. We'll put you back in the breakout room. Okay, Corey Grout. That's Petrovich. Are you handling that? at all?
Yes, Your Honor, I'm filling in for Mr. Petrovich on that.
I'm just gonna step out, talk to Mr. Lyons for the other exam I've got this morning.
Thank you,
All right, we'll stay around in case something needs to happen on Hale.
thank you. Okay. Grout, can you hear me?
Yes, Your Honor.
Okay, thank you. We're on the record in the matter, the people of the state of Michigan versus Corey Lee Grout. The file number is 21-01645FY. Council appearance.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Corey Grout, who appears with us today via Zoom. I'm filling in for counsel of record Charles Petrovich.
Thank you. How are you today, Ms. Grout?
I'm good. How are you?
I'm good, thank you. Today's the date that's set for sentencing. I do have a pre-sentence report and recommendation here. Did either you or her original attorney get that report?
We have received it, Your Honor, and it's my understanding Mr. Petrovich and Ms. Grout discussed that report yesterday.
Okay, is there any changes that need to be made?
None on our behalf, Your Honor. We believe it to be accurate as well as complete.
Thank you. Did you want to address the court prior to sentencing?
Yes, I would, Your Honor. Thank you. Ms. Grout is one of many who suffers from addiction, and her self-reported history of procrastination and disorganization is combined for kind of chaotic lifestyle. However, she does have that realization, and she is currently in and seeking help and treatment for that. She has been at the Glass House for approximately the last 5 weeks and is fully engaging in that treatment program there. It appears that she is looking at drug treatment court for her pending matters in Clinton County. I don't know what we could offer her much beyond what she is currently doing or will be doing there. She does have a substantial amount of jail credit on this case, 96 days, I believe. I would ask the court to consider sentencing her to the time that she has already served. Thank you.
Okay, Ms. Grout, you do not need to make your own statement. You have an attorney here to represent you, but if you would like to make a statement, you can do so at this time.
Okay, I'm just, I feel very blessed that I'm able to be in treatment right now, getting help for my substance abuse issues. So that's all I was really gonna state, and thank you, Your Honor, for.
No problem. Thank you. Actually, you look much better than the last time we saw you. I can see the brightness in your face returning. So you look like you're on the right track, and hopefully you'll remain on that, okay?
Okay, thank you.
Okay, the court has read the pre-sentence report and recommendation, and I would agree that you're already doing what is in your best interest, which is getting some treatment to address the underlying abuse issue, and then may even get some additional treatment through this pending matter you have. So there's no reason for the court to order any additional supervision at this time. You've served 96 days in jail. The court's going to give you credit for 96 days. There is a $75 crime victim rights fee and a $50 state minimum cost fee that is assessed, and both of those will be referred to collections, okay?
Okay, thank you, Your Honor.
You're welcome. Any additional matters for the record?
Nothing further on behalf of Ms. Grout, Your Honor. Thank you.
Thank you. Good luck, Ms. Grout.
Thank you, I really appreciate it.
You're welcome. Have a good one.
You too.
Thank you, Judge.
Thank you. Have a good one.
Mr. Abbott left. You want me to bring the jail back, Judge?
Mr. Abbott, are you all set?
I'm all set on Corey Hale, Your Honor. I'm also here on Corey McCulloch and Michael Siapi.
Okay,
I'm
sounds
ready,
good.
I'm
Thank you.
ready on when you are on those.
Yeah, we can. All right, he's got a bunch of co-defendants too.
So we thought this code was
So his co-defendants on a misdemeanor.
everybody else was.
Okay, so do you have the complaint? I can look at it too.
I'd have to go grab it.
I'll pull it.
Is McCullough supposed to be here in person?
Don't worry about it, Nick. I can.
Theoretically, Your Honor, yes. But he won't be.
Okay, McCullough has failed to appear. The court's gonna issue a bench warrant.
Thank you, Your Honor.
No problem.
Not yet. Let me take a minute. Are you guys ready to go on something?
No, I'm here I have like a 5 code
Oh, yeah.
cluster.
Okay. Would your honor then be willing to let me move for Ms. Shinzig's practice if this is a break in the docket, your honor?
Absolutely.
Okay.
What was his bond?
Okay.
No PR.
Why don't you go? The reason for the meeting.
Do you know, have you met Victoria yet?
No, I haven't.
Okay,
Hi.
Victoria, Miss Martin, he's our drug guy.
I
Victoria
think we
is
sat next to each other yesterday.
Oh, well.
our new
welcome
APA.
aboard.
Not drug guy.
She found out last night she passed the bar.
Congrats.
Woo-hoo.
That's great.
Man, what a feeling.
That is great.
Yes.
Which matter?
Word. Way too complicated. Yeah. I can barely handle the stack. Now you want me to use.
Well, could you?
I'm joking.
Amazing.
No, it's okay.
You had McCullough and then who was the other one?
So at this point, Your Honor, I am filing a nollie for Huntley. I have to send
Nickel.
the bench warrant for both of Mr. McCullough's files.
Is Huntley here?
Yes.
Huntley is here.
Okay.
And then I will be making a request for an adjournment on John.
Nolly, because you didn't have the witnesses?
That is correct, Your Honor.
Where's Huntley and her attorney? They're here?
Well, there's Mr. Oh, no, I'm sorry. Mr. Nickel is running a preliminary examination with Alderson right now, Your Honor.
Got it, okay. Did he let Huntley know she can leave?
I have not been able to convey this to anyone other than this court because he's
Yes, call Huntley in here.
on the record.
Mr. Abbott can handle it.
So I was, have you done an alley before? Okay, so our name goes here. Nick will print them for you. Not all the courts will, but Nick is really great. So with our name here, you read them here. So in this case, the people cannot proceed without the necessary witness when we have a victim fail to appear. Let me try it again. And Nick doesn't always know what our reasons can be, so he doesn't know reason for us. And then in today's date, sign. And your key number, which you don't have, so you can't actually sign these for it. I was under for us, but this is what it would look like when it is time. Then we put it on the record, and then I ask the court to approve.
Okay, we're on the record in the matter of the people of the state of Michigan versus Cherie Dominique Gail Huntley, file number 21-02832 FY. Appearances, please.
Thank you, Your Honor. Aaron Hosfield on behalf of the people.
Good morning, Your Honor. John Abbott with the Ingham County Public Defender's Office, representing Ms. Huntley this morning. Briefly.
Thank you. And thank you for filling in place of her attorney while he handles another matter. Ms. Huntley, today was the date that was set for your preliminary examination. However, the prosecution does not have the necessary witnesses to proceed. So they are going to make a motion to nollie this case. That means that the case will be dismissed without prejudice. That means that if the necessary witnesses later appear and they come to the prosecution and they want to proceed, the charges can be reissued. Do you understand that? Do you have any questions today for the court? Okay. Any additional matters for the record?
May I ask Honor Finale? Thank you.
Thank you.
Thank you. But nothing else for the people. Thank you.
Nothing from the defense, Your Honor.
Thank you. This case is dismissed. We can get you a copy of the nollie if you stick around, okay? You're welcome. Okay, I see Alfonso Weaver, but he's not started his audio. Somebody is on an iPhone.
Mr. Siapi.
Mr. Siapi just logged in. Okay, let's see if people start their audio. Who just joined me from an iPhone?
Asia Armstead.
Can you start your video, please?
So what?
Start your videos, okay. Ms. Armstead, you said?
Yes, Miss Armstead.
Okay, I don't see where she has an attorney. Did you request court-appointed counsel, ma'am?
Huh?
Did you request an attorney to be appointed to you?
Yes, I did.
Okay, give me a moment. Let me see what's going on with your application.
Your Honor, if I may briefly, we appeared on this case for a PCC last week, and there was no attorney assigned at that time either. So we would like to get the case moving forward and make sure that all the different people who are involved have a chance for a court-appointed attorney.
Okay, I think this is an issue where they're trying to find conflict counsel.
That's correct.
Well, court's not going to be able to do anything to accelerate that. I do know Mr. Carter appeared on one of those matters today. So I don't know, Mr. Abbott, do you have any way of knowing if there's anyone that's been appointed and maybe they just haven't filed their appearance yet?
Let me grab my computer, Your Honor, and I'll see what I can find out.
Thank you.
And just so the court's aware, I've made contact with Mr. Bigelow yesterday about these files, and he checked for me yesterday, and as of yesterday afternoon, there were no attorneys appointed for Ms. Armstrong and a couple of the other, Ms. Armstead and a couple of the other defendants.
Yeah, he would only have the information that we would have via an appearance. Someone from the public defender's office, because they're the one signing the paperwork now, would have known a little bit more than us, I would assume.
That makes sense.
Or at least be able to give us the status if someone is accepting the appointment. But we've not received any appearance on any of those. Okay. I see someone who doesn't have their audio on, no audio on that one. Okay, Kevin's iPhone.
Yeah.
Start your video, please. Okay. What's your name, your full name, Kevin?
Kevin Price.
Okay, Mr. Yang, is that your client?
It is, Your Honor. And I believe this is the case with the multiple co-defendants that you guys are talking about with conflict counsel issues. So, yeah.
Okay, sounds good. It looks like I have some more people logging in, but none of them have started their audio.
Y'all telling me to start my audio?
Yeah, it was you and at least two other people. But what's your name, sir?
My name Kevin Price.
Okay, Mr. Price, I have you checked in already. I see Dewan Bush.
Yes. Can you hear me?
Okay. I can hear you, thank you. I'm gonna mute you. Okay, DeFonso Weaver, can you hear me?
Yes.
Okay, thank you. I don't have attorneys on any of these. Liddell Brown, can you hear me?
Yes.
Okay. I'm gonna need to have an update as to whether or not the council has been located on Armistead, Liddell, Bush, and Weaver.
I don't have counsel, Your Honor.
Oh, I'm waiting for I have a public defender that was gonna look up one of the cases. I'm waiting for someone to look and tell me if they have an update.
Your Honor, I do not have an appointed attorney listed in our database for Miss Armstead. It's possible that if there is 5 co-defendants, that we just haven't located 5 people to take the cases yet.
That would make sense, but I just wanted to confirm before I reset their matter. I don't see the price file. I'm sorry?
You don't have price.
I don't have price. Mr. Nichol, while you were gone, I had Mr. Abbott handle one of your matters. It was a nollie.
Huntley?
Yes.
Yes, and he provided me the knowledge, and I believe provided to my client who is since left the book.
Very good, thank you. Okay, let's see. I'm just waiting on the price file. And then I can deal with these. But I'm only gonna set it 1 week because they need to get an attorney. Yes, please.
We need a bigger one.
Okay, so it looks like 2 of them received a conflict counsel so far. Okay, we're on the record in the matters of the people of the state of Michigan versus Kevin Price. This is file number 21-02871. Council appearance.
Chris Martin for the people.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Price. We're both present via Zoom and consent to having this hearing via Zoom.
Thank you. Mr. Price, can you unmute your device, please?
All right.
Today's the date that's set for a PCC. I just converted this to a PCC because we were waiting for you to have a counsel appointed. However, you were supposed to be here last week, Mr. Price, and you did not appear. I can't see you. Why did you not appear last week?
Because I got my days mixed up.
Okay, a bench warrant was signed, but it does not look like it was entered, so I'm going to quash the warrant. You have now been appointed counsel by way of Mr. Joseph Yang, and you've been in communication with him already, Mr. Yang?
Yes, Your Honor. We had a brief conversation on Friday. I'm awaiting discovery, and I've already requested that. So I have good phone number, address, and email for him. So I should be able to continue contact with him.
Okay, very good. Okay, so this matter, okay, let me admit Mr. Norris, who's in the waiting room. This matter is gonna be continued to an exam date. I'm not going to be able to give you an exam date now because not everyone on this co-defendant matter has received an attorney. And so it looks like at least 3 people are still waiting for conflict counsel to be appointed on their behalf. So once we can get that taken care of, we'll address or reset a preliminary exam date. Mr. Price, though, you were not here last week in which I addressed this for everyone else because of the matter having 6 co-defendants who cannot all have representation out of the same office. Defendants would need to have conflict counsel appointed, and so far you've received yours, but because of the delay that has caused, you're not going to be able to have your preliminary examination within the 21 days per constitutional right. So the court found good cause to adjourn the other matters beyond the 21-day time frame. I didn't do that for you because you weren't here. So I'm going to address that now. You have a constitutional right to have your preliminary examination within 21 days of your arraignment. You were arraigned on here back on October 14th, 2021. But because of the circumstances surrounding this and the co-defendant's appointment, I'm going to find good cause to adjourn that timeline. This matter will be set for an exam. It just won't be next week. Okay, sir?
Yeah.
Do you have any questions today?
Nah, nope.
Okay. Mr. Yang, anything else that we should address while we have Mr. Price here on this file?
Nothing further, Your Honor. I think that we will just await the date for the preliminary examination. I did receive a preliminary date, but I understand that might change. So I will await notice from your court.
Very, very good. Thank you very much. You're all set for today, Mr. Price.
All right.
Thank you, Your Honor.
Thank you. You're free to go. Okay, DeFonso Weaver.
Yes.
Okay. So on the record in the matter of the people of the state of Michigan versus DeFonso Weaver and file number 21-02873, counsel appearance.
Chris Martin for the people.
Okay, Mr. Weaver, today was the date that the court reset your probable cause conference. We were here last week and the court advised you that the request for a public defender was still pending because they need to find conflict counsel, someone outside of the public defender's office to represent you because one of the parties is already being represented by the public defender's office. That conflict counsel has not yet been located. Okay, sir?
Okay.
So because of that, the court's going to adjourn your probable cause conference for another week, and hopefully you'll have an attorney by then, okay?
Okay.
What time did you say next week? 8:30. The 25th? I'm sorry, I'm on the wrong week. The 4th. We're going to adjourn it to November 4th at 8:30, okay?
Okay.
You'll log in the same way you did today. Do you have any questions?
No.
Okay, thank you. You're all set. I'm not sure why it hasn't been this information in this. That's not the prosecutor. I don't know who this is. So they entered something incorrectly on here. So we need to get that out of JIS if that's in there, because it's on more than one document. Okay, Mr. Norris does have an attorney, correct? I think he was already represented by him. That's Mr. Nichols. I saw Mr. Norris log and he's there. We're on the record in the matter of the people of the state of Michigan versus Ricky Dwayne Norris, file number 21-02874, council appearance.
Chris Martin for the people. And Assistant Public Defender Scott Nickel on behalf of Mr. Norris.
Okay, today was the date that was reset for PCC because the co-defendants were looking for conflict counsel. They've not gotten conflict counsel, at least all of them have not gotten conflict counsel. However, we have tentatively set this for a preliminary examination on December 16th at 8:30 in the morning.
Thank you, Your Honor. That sorry, that date will work with my schedule.
Okay, and we actually chose that date because we're going to try to host this in Judge Ward's courtroom for additional space.
All right.
Any additional matters we should address while we have Mr. Norris here?
No, Your Honor. What time was that?
It's gonna be at 8:30, I'm sorry. I don't see any reason to host another PCC prior to that unless there's something we need to address. If I'm gonna host it, it's gonna be closer to the December 16th day.
Yes,
Okay.
and I think it would make sense if one needs to be set to wait until we are absolutely sure that is the date of the PE before we set up pieces.
Very good. Okay, so Mr. Norris, do you have any questions today?
No, you said that it's gonna be December 16th at 8:30 a.m.
December 16th at 8:30 a.m. So unless you have any questions for me, you're all set for today.
No questions.
All right, thank you. Have a good one.
You too.
Mr. Weaver, did you have a question?
No.
Okay, thank you. You're free to go then if you didn't have a question. Okay, Dewan Bush.
Yeah.
We're on the record in the matter of the people of the state of Michigan versus Deshawn Nelson Bush, file number 21-02872, council appearance.
Chris Martin for the people.
Okay, and Mr. Bush, similar to two other of your co-defendants, you've not yet been appointed conflict counsel, so they're still waiting for an attorney who can represent you, who's not a part of the public defender's office, okay?
Okay.
So this matter is going to be reset next week because I need to be able to follow up to make sure you have an attorney appointed to you, okay?
Okay.
So that's November 4th at 8:30. You'll log in the same way you did today.
Okay.
All right, we'll see you next week, sir, unless you have any questions for me today.
That'll be it.
Okay, thank you.
All right.
Ms. Armistead?
Yes, ma'am.
Okay, same with you. You don't have an attorney yet.
Your Honor, just for the record, Ms. Armistead is not awaiting conflict counsel. She was denied. She makes too much money. So if she is not eligible for service to the public defender's office or conflict counsel,
Got
she
it.
will need to retain her own attorney.
Okay, did you hear that, Ms. Armistead?
Yep.
Okay, so you're gonna need to hire an attorney. I'm gonna reset your matter for next week so that you can update the court on whether or not you found an attorney to represent you for this matter, okay?
Okay.
It's gonna be November 4th at 8:30. You can log in the same way you did today, okay, ma'am?
Yes, ma'am.
Thank you. You're all set today. Mr. Norris, you're free to hang up.
With Mr. Brown.
And Mr. Price, you were free to hang up. Thank you.
You know, I believe that's all of my cases for this morning.
And just so the court knows, and I think Mr. Brown knows this, he was denied as well.
I have this file. Did I give you Joe Brown by accident? Yes. Oh, I have it still, thank you. Okay, on the record in the matter of the people of the state of Michigan versus Liddell Brown and file number 21-02876. Have your appearance. Counsel. For the people.
Yes, Your Honor, thank you. Erin Housefield on behalf of the people.
Thank you. Today's the date that was set for we're converted to a probable cause conference because we're waiting for your application for court-appointed counsel to be reviewed. Mr. Brown, you've been denied court-appointed counsel. Do you understand that?
Yes, I do. I'll be defending myself.
Okay. So you wish to defend yourself in this matter as opposed to hiring a private counsel to represent you?
Right, I just simply can't afford it.
Did we set this for another exam date already?
Your Honor, my records reflect that the preliminary examination was set for November 4th at 8:30 a.m.
Okay, very good. So we'll see you in person November 4th at 8:30 in the morning, okay?
Okay.
All right, do you have any questions today?
No, I do not.
Okay, you're all set. Thank you.
Thank you, Your Honor.
You're welcome. Mark the record in that matter. Okay, Mr. Norris is back.
Hello?
Yes, did you have a question, sir?
Yes, was my next court date November 16th or December 16th?
December 16th.
December, okay.
All right, you're all set.
Okay, I'm putting it down in my calendar.
Thank you.
You're welcome. Thank you.
Okay, and is it Kiafi?
Yes, ma'am. For the record, it's pronounced Siafi.
Siafi, thank you. For on the record in the matters of the people of the state of Michigan versus Michael Albert Siafi Jr. File numbers 21-02819 and 21-02724. Council appearances.
Thank you, Your Honor. Erin Housefield on behalf of the people.
Good morning, Your Honor. John Ammett, on behalf of Mr. Siafi on the felony case.
Okay. Okay, today's the date that's set for a probable cause conference. How are we proceeding on that matter?
Your Honor, there was a discussion early in the case that we might resolve both these files, 21-2724 SM turned out to be a conflict situation since his wife is a co-defendant. So I can represent him on the felony, but not on the misdemeanor. And we'd ask the court to leave the felony preliminary exam on the schedule, and we'll hold that next week.
Okay, so is conflict counsel being sought on the misdemeanor, or is he just being denied counsel on that?
It's being, conflict counsel is being sought, Your Honor.
Okay, that one actually was set for the November 4th date already, so we'll keep that date.
Okay.
Okay, so then both these dates will continue to November 4th at 9:30 in the morning. Any additional matters for the record?
Nothing for the people, Your Honor. Thank you.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Siafi. We'll see you next week.
Ma'am, is it in person or is it via Zoom?
Yes, in person.
Okay, thank you.
You're welcome. Okay. What do we have next?
Your Honor, I think if we may do the Micum John 2102828 FI matter.
Okay, we're on the record in the matter of the people of the state of Michigan versus Michael Nathaniel Laverne John, file number 21-02828. Counsel Cat.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Misham John, who is present in the courtroom to my right.
Who are you today, Mr. John? Today's the date that was set for preliminary examination. How are we proceeding?
Thank you, Your Honor. At this time, the people will be making a request for a good cause adjournment. I did make an offer on this matter and conveyed that to Mr. Keithley on Tuesday. I also advised him at that time that should his client prefer to have the preliminary examination, that I would be seeking an adjournment if not stipulated to, because in speaking with the victim, Ms. Camilla Jones Quinn, she indicated that she had an appointment scheduled this morning that had been set for some time and she would not be able to reset that. I understand that Mr. Keithley was not able to provide a stipulation to my request for that adjournment, and so we are before the court and I am making this good cause request.
An appointment, was it a medical appointment?
Your Honor, I try not to get too in detail with people with regard to their medical. When she tells me that she has something scheduled that she cannot reschedule and that has been set for some time, I take that to be what it is.
Okay, Mr. Keithley.
Thank you, Your Honor. At this time, we would be moving that this matter be dismissed. As I understand it, it sounds like the prosecution doesn't have any witnesses and is unable to proceed at this time. This is a scheduled court hearing. Presumably, they did actually send a subpoena, which would be a court order to appear to the alleged victim in this matter, and she has chosen not to comply with that. So, of course, if they establish communication later on and she chooses to comply later, they could refile this matter, but at this time, we would be asking for a dismissal.
And you discussed that with your client about having to repost bond if this was refiled, correct?
We didn't actually get too far into that, Your Honor, but he and I will discuss that.
Okay.
He is on a PR bond, Your Honor. We anticipate that he would be able to, considering that none of his criminal history will likely change in the interim time, I expect he will be able to get back out on bond.
Okay. You know, the court has no problem adjourning a matter at the request if it was for something such as a medical appointment. But it could be a hair appointment for all I know, because I don't have that information before me. There was a court order for her to be here, or she was supposed to be here because there was a preliminary examination set. The defendant is here. The defense is ready to proceed. I'm going to grant the request to dismiss this case without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, we're off the record on that one. Mr. Abbott is back. Well, which matter is in the back here?
Thank you, Your Honor. Juan Lopez. Your Honor.
Lopez?
He's best, you know.
Oh,
that's Derek Mitchell.
Okay, we're on the record in the matter of the people of the state of Michigan versus Juan Jose Lopez, file number 21-02696. Counsel appearance.
Good morning, Your Honor. Adam Piker for the people.
Good morning, Your Honor. Tuna Brown Levine on behalf of Juan Lopez.
Is Mr. Lopez in custody?
He is in custody, Your Honor.
Okay, he's not in the courtroom, correct? Okay, we're off the record. Mr. Lopez is not here. That's the end.
I'm sorry, I didn't say it loud enough, Your Honor.
No problem.
Thank you.
This is it. Who is this?
Mitchell.
Okay, from Clinton County. That's yours, Mr. Nicole?
Yes. There's going to be a misdemeanor plate.
Let me sign this really quickly. we're on the record in the matter of the people of the state of Michigan versus Derek Jarrell Mitchell. File number is 20-02243. Council appearance.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Assistant Public Defender Scott Nickel on behalf of Mr. Mitchell.
Today's the date that was set for a preliminary examination. How are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant will be entering a plea this morning.
Can you place the offer on the record?
Thank you, Your Honor. The defendant will plead guilty to an added count 3 of use of a controlled substance pursuant to 333.74042A. That is a 1 year and or $2,000 maximum penalty. In exchange for that plea, Your Honor, the people will move to dismiss counts 1 and 2. Additionally, Your Honor, the people will not raise an objection to a no upfront jail sentence.
Mr. Nickel?
That is a complete and accurate statement of the plea agreement that's been reached in this matter.
Thank you. And how are you today, Mr. Mitchell? Did you hear the offer extended by the prosecution?
Yes, ma'am.
Do you want to accept that offer?
Yes.
Can you raise your right hand? Do you solemnly swear or affirm that the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Put your hand down. Mr. Mitchell, you have the right to proceed to a jury trial in this matter. You have the right at the time of jury trial to have the prosecution prove each element of the charge against you, or the charges against you. They need to prove each element beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
You want to accept the plea and enter a guilty plea today to the added count 3 of use of controlled substance, you would have to give up your right to have a trial of any kind. You want to do that today?
Yes, ma'am.
So that means you'll never have an opportunity to cross-examine or question any of the witnesses that the prosecution intended to call against you. You won't have the opportunity to call your own witnesses to further any defense that you may have. You won't have an opportunity to present any evidence to further any defense that you may have. You also waive your right to remain silent at trial and not have silence be used to prove your guilt. Do you understand that?
Yes, ma'am.
Anybody made any promises to you to get you to waive your rights today?
No, ma'am.
Anybody threatening you to get you to plead guilty today?
No, ma'am.
Are you pleading guilty because you believe you are guilty?
Yes, ma'am.
Are you currently on probation or parole?
No.
You understand that a criminal conviction could cause you to have to report that to future job applications, sir?
Yes, ma'am.
As to the added count 3 of use of controlled substance, how do you plead?
Guilty.
On a factual basis.
Yes, Mr. Mitchell, back on August 2nd of 2020, were you driving a vehicle in the city of Lansing?
Yes.
And in the location of West Oakland Avenue and Westmoreland Avenue?
Yes.
And at that time, were you stopped by police?
Yes.
The officer informed you he stopped you because you had warrants for your arrest at the time?
Yes.
And did he actually place you in arrest under those warrants?
Yes.
And after placing you in arrest, did he conduct a search of your person?
Yes.
And while doing that search, did he find a substance that you admitted was crack cocaine?
Yes.
And you knew that that was crack cocaine?
Yes.
And you were in possession of it?
Yes.
You didn't have any lawful right to possess that?
No.
Your Honor, I believe that's a sufficient factual basis.
Your Honor, thank you. I would just ask that the court take judicial notice that the address as given by Mr. Nickel, which is in the city of Lansing, is also within the county of Ingham and state of Michigan.
Thank you. If the court is satisfied with the factual basis, I'll take judicial notice of the address being in the city of Lansing, Ingham County. Found your plea be made to me voluntarily and intelligently. This matter will be set for sentencing on January 7th, 2022 at 8:30 in the morning. Prior to sentencing, you need to meet with probation. They're going to provide the court with a pre-sentence report and recommendation. You also are going to have to undergo a substance abuse assessment, okay? How long is he going to be in Clinton County?
It's my understanding he's awaiting sentencing and is likely going to be there until sometime in February. So my expectation is he would be in Clinton County Jail at the time of that sentencing, and so the PSI interview would need to be conducted.
Do you have any questions today, sir?
No, no.
Any additional matters for the record?
And nothing for the people, Your Honor.
Nothing for the defense, Your Honor.
Thank you. You're all set for today, sir. Okay, give me a second. I'll be right back. For the record, in the matter, the people of the state of Michigan versus Juan Jose Lopez, file number 21-02696, FY counsel appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
Good morning, Your Honor. Attorney Barnett Levine on behalf of Juan Lopez, who's present standing on my right.
How are you, Mr. Lopez? I can't hear you.
Yes.
How are you?
All right.
Today's the date that's set for preliminary examination. How are we proceeding today?
Your Honor, the people will be asking for a good cause adjournment in the matter, as there have been contacts with the victim that amount to witness interference, Your Honor, and extremely blatant ones. Because of this, the people will be getting Detective McBride, who's currently assigned to the case, to review the calls, write a report, and be available to testify to add a 10-year felony of witness interference to this matter. Because of that, we ask for an adjournment rather than starting today and then continuing out. Additionally, while the people did have their officer here earlier, he had other court engagements that he had to be at, and so we would have to wait even longer for him to be able to return here and testify. So for purposes of judicial economy, I believe it would just be easiest to adjourn the matter in its entirety. I can give a proffer as to what is contained in these calls. I have shared one of them with the defense attorney this morning. There was a technological issue where the calls couldn't be sent via email. It was being bounced back as a, quote, security concern, but I was able to show him some of them this morning.
Thank you. Counsel?
Yeah, Your Honor, so I completely understand what my brother counsel is saying. Not to make too fine of a point, not make it trivial, but perhaps duty bound to ask for the matter to get dismissed, as the court would imagine. And maybe if we could frame it in the way that if there aren't necessary witnesses that are available for that, and there's going to be even a little bit of an allocution about having a new matter being reissued on the violation, then that would be a separate independent count. So, on behalf of my client, would ask for the matter to be dismissed. But I do concur that I did hear the video or the audio this morning.
Okay. Based on the information provided to the court, which I'm not going to require you to proffer any additional information, I think it's sufficient to suffice it to say that there's been phone calls, which some have been shared with defense counsel, that would represent an witness interference or intimidation of the victim. So the court will grant the request to adjourn this matter to allow you to continue to review those phone calls and determine if there's going to be additional charges stemming out of that before we proceed on the examination. So because of that, the court's going to find good cause to waive the 21-day time frame for your preliminary examination. This matter will be set for a new date. Are we talking about a lot of phone calls here, or will adjournment for a couple of weeks be sufficient?
A couple weeks should be sufficient. The problem is he called a lot of different people, three-way call through the same phone number. So it's hard to pinpoint just from looking at the call log specifically how many are to the victim, but there are at least 5 or 6 of them found so far.
November 18th at 8:30. November 18th at 8:30.
And I would like to place the offer on the record, Your Honor. Thank you. The defendant is currently charged with 5 different counts. The first being armed robbery, which has a maximum penalty of life in prison. Second being home invasion, first degree, maximum punishment up to 20 years, which is a discretionary consecutive sentence with any other charge. Third being unlawful imprisonment, a 15-year felony. Fourth being felonious assault, a 4-year felony. And finally, a misdemeanor domestic violence charge. The people will also be seeking to add a count of 10-year witness interference, which is a 10-year discretionary consecutive to any of these charges. Now, the offer that was initially extended was that the defendant could plead guilty to an attempted unlawful imprisonment, felonious assault, and domestic violence. That offer would expire upon the commencement of preliminary examination or the discovery of information that would amount to witness interference, which we have certainly reached that point for my office. However, I'm willing to keep that offer open until the preliminary examination date of November 18th. I would also include in there a Killebrew agreement to not seek or add witness interference charges for any communication that happened prior to that plea. That way there is no concern or doubt as to the status of what's already been done if you were to accept the plea. I would note the estimated guideline range that I estimated this morning. As charged, the guideline range is 108 to 180 months as the minimum, which is near at least near 10 years. The offer that has been given, the guideline range is 10 to 23 estimated. Again, it's 10 to 23 months, not 10 to 23 years. And that offer will be kept open through November 18th, the preliminary examination date.
Counsel, that's the offer that you recall being extended for your client.
Indeed, it is, Your Honor. I appreciate counsel saying on the record that my client here, including the amount of time. So.
Okay, thank you. So this matter will be adjourned. You just received notice of your next date for your preliminary examination. Any additional matters for the record?
Nothing for the people, Your Honor.
I'm just not for the defense either, Your Honor. Thank you.
We're all set. Okay.
Thank you.
Mr. Abbott, I think your client's in custody, correct?
I believe he is, Your Honor, yes.
Okay, they should be bringing him up then. They just brought someone downstairs.
Oh, great. Thank you. Then I can do this live.
Sounds good.
No, he really ain't taking no plea. So you better not be taking no plea deal.
I ain't taking nothing. I know, I ain't doing anything. So they told me don't let me out. I said, don't let me out. I don't have nowhere to go. Just keep me in jail. The place I had to go, y'all still can't go there.
Did we, oh, now someone in the way.
Oh, yeah.
Started.
Yeah, he making scratch.
Mr. Love, can you hear me?
Yes, ma'am.
On the record in the matter of the people of the state of Michigan versus Kenneth Love, file number 21-02780 FY, council appearance.
Thank you, Your Honor. Aaron Housfield on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Love. We are both appearing by video this morning.
Thank you. Today was the date that was converted to a, well, we converted to a PCC, but it still says preliminary exam on the docket. Last week, we were still waiting for court-appointed counsel, and my understanding, Mr. Abbott, is that you have been recently appointed on this matter. Is that correct?
Yes, Your Honor. I received notice yesterday afternoon around 4:40. Our appearance was filed, but we have not yet received a police report.
Okay, so because of that, this matter will not be proceeding to exam. We need to adjourn this. We also need to address the 21-day timeline today because I don't think I addressed it last week. So, Mr. Love, you have the constitutional right to have your preliminary examination within 21 days of your arraignment. Because you were not appointed counsel, can you hear me?
I'm definitely one under right here. That's what I'm trying to decide so I can hear all this here. I'm trying to hear you as best as I can.
Okay, sounds good. Can you?
I always definitely hear, but I tend to turn to this side because I know I can hear better out of this ear. I was trying to
Okay, but can you hear me clearly? Can you hear me clearly?
I can now, but I didn't hear the things you were saying before then. That's why I was.
No problem. I'll repeat it. I was telling you that you have the constitutional right to have a preliminary examination within 21 days of your arraignment. But because you did not have an attorney appointed until yesterday evening, the court is going to find good cause to waive the 21-day timeline. So you'll still have your exam, but it just won't be today, okay?
Okay. Oh yeah. Can I ask what happened to the lady that came to visit me on the 26th? I thought that was my court-appointed attorney.
I have no idea who visited you on the 26th, so I can't speak to that.
Your Honor, I believe it was a member of our staff. They reevaluated his court-appointed attorney application, and that was the purpose of that visit.
Okay.
So that after they reevaluated his financial situation, then he qualified for an attorney.
Okay. Does that answer your question, Mr. Love?
I guess, yeah.
Okay. So Mr. Abbott has been appointed to represent you. I'm going to reset this matter for a preliminary examination. He's still awaiting discovery, and he'll be in further communication with you. Okay, sir?
Okay.
I don't know if you have a PCC.
I've already conveyed an offer, Your Honor, to Mr. Abbott. I don't believe that we need a PCC. I'll let Mr. Abbott indicate to the contrary, but I believe just proceeding on to preliminary examination would be appropriate.
Thank you. Mr. Abbott, do you need another PCC date?
No, Your Honor, we're ready to go. We'll be ready by next Thursday for a preliminary exam.
Okay. Okay, so the exam will be on November 4th at 9:30. 9 a.m. At 9 a.m.
Okay.
Any additional matters for the record?
Nothing for the people. Thank you.
Nothing for the defense, Your Honor. Thank you.
Thank you. Thank you, Mr. Abbott. You're all set for today, Mr. Love. Okay, we're on the record in the matter of the people of the state of Michigan versus Colin and Alexander Voss, file number 21-02471FY. Council appearance.
Thank you, Your Honor. Aaron Housfield on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Colin Bose. He is present and to my right at council table.
Thank you. Today is the date that's set for preliminary examination. How are we proceeding today?
Thank you, Your Honor. It's my understanding that the defendant wishes to enter a plea.
Okay, what's the offer?
Thank you, Your Honor. The defendant is going to plead to an added count 2 of weapons, dangerous weapons, using self-defense spray attempt, and that is pursuant to 750.224D2, and then a bracketed A, Your Honor, for the attempt. As an attempt, the maximum penalty is 1 year and or $1,000 with a mandatory forfeiture of the weapon pursuant to MCL 750.239. In this instance, Your Honor, the weapon carried was a knife.
Okay, so it's the dangerous weapons attempt.
Dangerous weapons using a self-defense spray device attempt, Your Honor. And I'm sorry, Your Honor, in consideration for that plea, the people would move to dismiss count 1.
Thank you.
Thank you.
Mr. Austin.
My understanding as well, Your Honor.
Okay, and Mr. Bose, you heard the plea there?
Yes.
Okay, you wish to accept that offer?
Yes.
You raise your right hand. The other hand.
Okay. Sorry.
No problem. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can pick that up from, please. Thank you. Okay, and sir, you understand that you have the constitutional right to proceed to a trial in this matter?
Yes.
You have the right to have a jury trial. At the time of trial, you have the right to have the prosecution, bring sufficient evidence to prove each element of the charge against you. They have to prove each element beyond a reasonable doubt. Do you understand that?
Yes.
In a guilty plea today, you would be effectively waiving your right to have trial of any kind. That means you'll never get an opportunity to cross-examine any of the witnesses that the prosecution intended to call. You'll never have an opportunity to call witnesses or present evidence to your defense. You'll also waive your right to remain silent at trial and not have silence be used to prove your guilt. You understand that?
Yes.
Okay, and is anybody making any promises to you to get you to waive your rights today?
No.
Anybody threatening you to get you to waive your rights and plead guilty?
No.
Are you pleading guilty because you believe you are guilty?
Yes.
Okay, I have an advice of rights and plea information sheet with today's date on it. That's your signature, sir?
Yes.
Do you have any questions regarding this document?
No.
Okay. As to the added count 2 of dangerous weapons using a self-defense spray attempt, how do you plead?
Guilty.
Can I have a factual basis?
Yes, Your Honor. Mr. Bose, I want to take you back to September the 6th of this year, 2021. You recall events of that day? Yes. Is it true you were in a motor vehicle at or near the location of 5010 Dunkel Road in Lansing, Michigan? Yes, I was. Is that in Ingham County? Yes. And in that motor vehicle, you had what would be construed as a non-folding double-edged stabbing instrument, is that correct? Yes, I did. And you knew that was there? Yes. And that's because you had placed it there? Yes.
Any additional questions?
No, Your Honor, thank you. The people are satisfied.
The court is also satisfied with the factual basis, and I'll accept your plea. Finding a plea to be made fully voluntarily and intelligently. This matter is going to be set for sentencing. Prior to sentencing, you're going to need to meet with probation so they can provide the court the pre-sentence report and recommendation. Your sentence date set for January 7th, 2022 at 8:30, okay? You'll get a copy of that notice to appear if you've not already received that. Is there a good mailing address for you, sir?
6021 Rutherford Avenue, East Lansing.
Do you have any questions today, sir?
No, I do not.
Any additional matters for the record?
Nothing for the people, thank you.
I may address bond, Your Honor.
You may.
Yes, thank you, Your Honor. Seeing that there has been a reduction in the severity of the charge from a felony to a misdemeanor, and Mr. Moses, 19 years old, he does have family in the area. He reports to me that he would be staying with upon release. However, he does have a matter pending in Lake County, so he's likely not to be released, but this would give him the ability to get transferred up there so he could take care of that matter. Given that, Your Honor, I would ask the court to consider reducing his bond to a personal recognizance.
Mr. Bowles, originally, at the time of your arraignment, there was a personal recognizance bond issued in the amount of 2,000 personal recognizance. However, that was forfeited when you didn't appear to your court date that you had back on the 24th. So is it going to be a problem for you to get back to court?
No, it will not.
Okay, I think you told the judge at the time of your arraignment on the bench warrant that your phone was broke.
Yes.
Okay, so you gonna be able to remember your January 7th date?
So
Okay. The court will convert the 5,000 10% bond to a PR bond, 5,000 personal recognizance. You need to make sure you return to court for your future court date. Your sentencing can be via Zoom if all parties consent.
The people would consent, Your Honor.
We would as well, Your Honor.
You can actually log in from Zoom from your electronic device as long as you have video, rather than come in person for your sentencing, okay?
Thank you.
You're welcome. Do you have any questions today? Any additional matters for the record?
Nothing for the people, thank you.
Nothing on behalf of Mr. Bowles, Your Honor. Thank you.
Thank you. You're all set.
Oh, okay, okay.
You print that motion for the sign. I believe you're the one I want. Okay. Mr. Bigwell, do you know what this is for? You know what that's for? Okay. Well, then maybe this belongs to you then. Sean
Yes.
dropped this off and I didn't know what you wanted me to do with it.
Oh, no, that's for
Okay, sounds good.
But I just sign it too. Thank you. Oh, they're still in. Then I'll finish it. Your Honor, may I put
You may, and it's pronounced Shinzing.
Yeah.
Okay, are we on? Okay, well, on the record in the matter of Victoria Shinsing, there's a motion by the people for admission under Michigan Court Rule 8.120. Ms. Housefield?
Thank you, Your Honor. The people have just provided the court with a written copy, which I will advise. Now come the people by and through Assistant Ingham County Prosecutor Aaron E. Housefield, who moves to have Ms. Victoria Shinzing, who's standing to my right, a May 2021 graduate of the Detroit Mercy School of Law, which is approved by the American Bar Association, to perform functions and duties comparable to an assistant prosecuting attorney before this honorable court pursuant to Michigan Court Rule MCR 8.120 sub D sub 4. Ms. Shinzig certifies that she has read and is familiar with the Michigan Rules of Professional Conduct and the Michigan Court Rules. Wherefore, counsel respectfully requests that this honorable court administer an oath, which is reasonably equivalent to the Michigan lawyer's oath, in requiring, at a minimum, to promise to the following: to support the Constitution of the United States, to support the Constitution of the State of Michigan, to maintain the respect due to courts of justice and judicial officers, to never seek to mislead a judge or jury by any artifice or false statement of fact or law, to maintain the confidence and preserve inviolate the secrets of the client, to abstain from all offensive personality, to advance no fact prejudicial to the honor or reputation of any party or witness unless required by the justice of the cause, and in all other respects conduct herself personally and professionally in conformity with the high standards of conduct imposed upon members of the State Bar of Michigan.
Thank you. And Ms. Victoria Shinzing, congratulations first.
Thank you.
Okay, can I have you raise your right hand? Repeat after me. I do solemnly swear or affirm.
I do solemnly swear or affirm.
I will support the Constitution of the United States and the Constitution of the State of Michigan.
I will support the Constitution of the United States and the Constitution of the State of Michigan.
I will maintain the respect due to courts of justice and judicial officers.
I will maintain the respect due to courts and judicial officers.
I will not counsel or maintain any suit or proceeding which shall appear to me to be unjust.
I will
not counsel or maintain any suit or proceeding which shall appear to me to be unjust, nor any defense except such as I believe to be honestly debatable under the law of the land. I will employ for the purpose of maintaining the causes confided to me such means only as are consistent with truth and honor, and will never seek to mislead the judge or jury by any artifice or false statement of fact or law. I will maintain the confidence and preserve inviolate the secrets of my client and will accept no compensation in connection with my client's business except with my client's knowledge and approval. I will abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of a party or witness unless required by justice of the cause with which I am charged. I will never reject from any consideration personal to myself the cause of the defenseless
cause the defenseless
or oppressed,
or oppressed,
or delay any cause
or delay any cause
for malice.
for malice.
I will in all other respects
I will in all other respects
conduct myself personally
conduct myself personally
and professionally
and professionally
in conformity with the high standards
in conformity with the high standards
of conduct imposed upon members of the bar
conduct imposed upon members of the bar
as conditions for the privilege to practice law in this state.
as conditions for the privilege to practice law in this state.
Thank you. Congratulations.
Thank you.
And I will sign here. Granting the motion for today's date. I don't see where you need to sign, so you're all set to practice before my court.
All right, thank you. Shall I just file this with the clerk's office?
Yes,
later?
please.
Okay, thank you.
Thank
You
you.
will take care of that.